Now, we know that our justice system is anything but perfect, as the number of false convictions and exonerations keep piling up. But is anyone ever held accountable? A new piece by Radley Balko in the Huffington Post today takes a look at prosecutorial misconduct in the United States and how a system of self-regulation and professional sanctions just isn't enough. So he joins me now to tell us more. Hi, Radley. Thanks for being here.
My pleasure.
And I encourage everyone to read this entire piece. It's in our resource well because it is very long and in depth. So we'll try to fit in as much as we can here. But, you start really talking about the story of John Thompson. And just tell us a little bit about his backstory, why this is such a key figure in what you're talking about.
Well, Thompson was in Orleans Parish, Louisiana. He was convicted of two separate crimes, actually. One was an armed robbery. The other was a murder. And he was actually later exonerated of both crimes. And basically what happened was he was convicted of the armed robbery, and then because of that was prevented from testifying in his murder trial because the prosecutor would have been able to bring up the armed robbery conviction. So he didn't end up testifying in the murder trial, which means he couldn't give his alibi. So he was convicted and sentenced to death. Years and years later, he was exonerated after a prosecutor came forward and said that one of the prosecutors in the case admitted on his deathbed that there was some blood on a piece of clothing that was left at the crime scene of the armed robbery, and the blood was from the perpetrator of the crime. The blood was tested. It did not match Thompson's blood type. Now, the blood and the swatch of cloth have never been found. But the results of the test were found when an investigator from Thompson's defense team was going through an old file at a police station. At this point, Thompson he was on his 8th death warrant, was days away from execution, and it was really just happenstance and luck that they came across this, and learned that there was this massive cover-up going on, that these prosecutors had basically lied about this evidence in order to preserve his conviction.
Yeah, I mean, bottom line, that's the really egregious part here, right, is that prosecutors knew that there was evidence, and yet they pushed ahead to sentence a man to death who they knew wasn't guilty. And so I guess, some of the questions that arise, too, are, why is there no accountability here? It's not like this is the only case. It is not unique, unfortunately. And so what are some of the protections that prosecutors have, and, and why are they in place?
Sure. So prosecutors have what's called absolute immunity from civil liability in these cases. So you cannot sue a prosecutor virtually under any circumstance. There are a few very limited windows you can get through. But for the most part, as long as they're acting in their role as a prosecutor, even if they manufacture evidence that results in your conviction and you're innocent, egregious negligence. In another case that I also wrote about in that story, there was a prosecutor was accused of basically arresting witnesses for the defense so that the defense attorneys could never get access to them. And the federal appeals court ruled that even if that was true, the prosecutor was still protected by prosecutorial immunity, and there was no civil liability for this guy, in this case, a guy named Sharif Kuzan, who had been wrongly convicted as well. So, that's on the civil side. On the criminal side, it's rare, vanishingly rare for a prosecutor to face any sort of criminal sanctions in these sorts of cases, which really just leaves this idea of professional accountability, and that's kind of what the article gets into. Thompson's case went before the Supreme Court, and the Supreme Court basically threw out a $14 million settlement that he had won from a lower court. And the reasoning in the majority opinion, which Clarence Thomas wrote, was that professional sanction is basically sufficient to keep prosecutors in line. And so, where this story actually takes place in Orleans Parish, the very same parish that Thompson's case arose out of. And since that decision came down, there have been numerous complaints filed against prosecutors in Orleans Parish. And in some cases, the people who filed the attorneys who filed the complaint haven't even gotten acknowledgement of receipt from the oversight board that's supposed to be holding these prosecutors accountable. And it's been months, and in one case over a year since they filed these complaints. So, I mean, the idea here is if all we have is professional sanction to keep prosecutors from committing this kind of misconduct, the very jurisdiction that case came out of is showing that just isn't working.
Yeah, and well, professional sanction, self-regulation, we know these are things that do not work. They certainly don't work in other industries as well. And it goes all the way to the top. I mean, you focus a lot on Louisiana here, but you also mention, just the Obama administration's Justice Department and things like having Eric Holder investigate Eric Holder, when it comes to looking into why it is that they wanted to label a reporter, James Rosen, a co-conspirator. And so, I guess, one of the questions here is just, where do you go from there? Where do you start in order to try to reform the system?
Yeah, that's the tough question. The Supreme Court has made its rulings in these cases, and with the absolute immunity, it was really, you want to talk about judicial activism. I mean, there's no mention of absolute immunity in the Constitution. There's no mention of it in previous case law. There's no mention of it in the section of the U.S. Code that allows for these sorts of lawsuits. It was really just something the Supreme Court sort of invented out of whole cloth in the 1970s. So, I don't know how you go back on that. I mean, Congress, I guess, could try to pass a law restoring some sort of liability for prosecutors. But, if you look at even sort of minor sanctions, I mean, even when an appeals court, a federal appeals court, when they throw out a conviction because of prosecutorial misconduct, they don't name the prosecutor in the opinion. So, when that prosecutor runs for re-election, his name doesn't appear in these opinions where he's being, criticized for breaking the rules. It makes it more difficult to find, for journalists, for example, to find repeat offenders because, you can't just do searches on a prosecutor's name in a legal database. I mean, even something that minor, like just mentioning them by name when they were found to have, significantly altered a case with misconduct, even that it appears to be too much. So, I guess it's kind of a cynical article, and that it doesn't lay out a lot of, possibilities for reform or avenues for reform. But I think, I guess getting more people to recognize the problem is maybe the first step.
Yeah, that's definitely where you start. And, you look into some of the reasons why we see this happening as well, which is just that, an encouragement, obviously, as a prosecutor to have more victories under your belt, and how looking like someone that is tough on crime can end up then helping you to further your career and your success. So, Radley, thank you so much for joining us. And for everyone at home, definitely encourage them to go and read the entire piece.